We'll hear from the appellant when you're ready.
May it please the court, would ask to reserve 3 minutes for rebuttal.
That'll be fine, 3 minutes.
Good afternoon, Your Honors. My name is Matthew McClanahan from the Cumberland County Bar, rising on behalf of the appellants in this case. The case before the bench today is a fairly straightforward matter and deals primarily with contract interpretation. The document that is before the court and that was entered as a trial exhibit at the court contains sometimes conflicting and hard to understand provisions, but one that is very clear and in fact specifically addressed within it is the provision for a no sale, which is the undisputed fact in the case before us today. A brief recitation of the facts is as follows: that the parties contracted to sell a certain piece of real estate located in Cumberland County, Tennessee, and entered into the contract previously referenced for the sale of said property. Contract was drafted by the plaintiff in this case, Amonett Eagle Auction, and an online auction was decided as the means for conducting the sale. During the course of the sale, there were a total of 11 bidders. 9 of the bidders, by the plaintiff's characterization, they termed them as bona fide bidders. And a dispute as it relates to the remaining 2 bidders, one being an Amanda Paragon, who was identified at the trial court, and the other being the Norris brothers themselves through an entity that they controlled. We would submit to the court that this provision, the fact that the Norris brothers themselves may purchase the property or may submit bids, was in fact calculated when drafting of this contract. In fact, that one of the provisions provides that there would be a reduced buyer's premium should one of the partners, one of the Norris brothers, actually purchase the property. However, the sale as it went online was not consummated. There was no closing that was held, and no real estate.
Let me just stop you right there and help clear up some confusion in my understanding. Why would the Norris brothers put a property up for auction that they would then bid on themselves?
Yes, Your Honor. So there are multiple entities that the Norris brothers owned. One entity is Norris Brothers Properties, LLC, which is the entity that owned this piece of property. The Norris brothers' usual vocation they're in the construction business, excavating business, and they have an entity known as Norris Brothers Excavating, LLC. Same partners, same people.
So was the winning bid Norris Brothers Excavating?
There was some discussion about that. It's my client's position that the winning bid was Norris Brothers Excavating, which is still controlled by these same parties, these twin brothers.
It's just still weird to me why you would basically, buy a property from yourself for more than you.
It might be, Your Honor may think of it like taking money out of your right pocket and put it in your left-hand pocket.
Unless you thought the shill bidder was going to drive it up and would be the, that's kind of what it looks like to me. They had a shill bidder, they were hoping it would drive it up and somebody else would buy it, and they ended up with it.
The testimony at trial did indicate that there was some discussions. Now, there's a dispute, factual dispute as it relates to whether or not Amonett's auction was aware of the fact that there was a bidder that was there to provide for an increase in bid amounts. My client testified that was the case. But the intent here was that was to sell the property. But if there was no sale, if for some reason the property didn't sell, then there were contractual terms to that effect. In fact, there was a specified amount for that. Of course, this court is very well versed in the fact that we are to look at the 4 corners of a document, and that Tennessee courts give primacy to the contract terms, because the words are the most reliable indicator of what it is that these 2 parties agreed to. Also, a well-established rule that the drafter of a contract, to the extent that there are any ambivalent or vague terms, are to be construed against the drafter. Whereas in this case here, no question that Amonett's Eagle Auction and Realty, LLC, was the drafter of this agreement that was entered into between these parties.
Do we care about the terms of the contract, though? Because this really wasn't a breach of contract claim. It was a fraudulent inducement, misrepresentation, et cetera, et cetera. And I think that's what the trial court based the damages on, right? It was not contract damages, but basically fraud.
Well, we do for 2 reasons, Your Honor. So we would posit to this court that the question is not whether or not the plaintiff is entitled to recover certain, expenses related to the sale of this, property attempted sale. My clients are businessmen. They certainly understand that. We would say that the court misinterpreted this contract in applying what was to happen in the case of a no sale. That the contract provides that there's to be a $25,000 payment plus the costs and expenses under Section 2. And we think that that's the reason why this case should be reversed and remanded back to the trial court, is because the court simply didn't apply that issue. As it relates to the fraudulent inducement and misrepresentation component of this, we think that the court obviously didn't get that right either. As it relates to this matter, the contract itself deals with the contemplation that a partner may purchase the property. So obviously, both parties were aware, by evidence by this writing, that the property may be sold to a partner and that they may be engaged actively in this bidding process. It would seem to go against equity for the plaintiff in this case to then turn around and say, well, I had no idea that they were then going to try to buy this property, or that there might be some issue if the property didn't bring a high enough premium at the auction block. For that reason, we think that the court misinterpreted the bargain that was struck between these parties. Without question, again, the property did not sell. There was no transfer. This court has previously...
Excuse me, why
Yes,
didn't
Your
it sell?
I'm sorry, Your Honor?
Why didn't it sell?
The property did not transfer because the buyer, in this case, this entity that was controlled by the Norris brothers, did not consummate the sale, so there was no closing. So they chose not to purchase the property because of a low purchase price.
So the reason the sale didn't go through was because of the Norris brothers.
Well, it was because that, so yes, the Norris brothers did not purchase the property through that entity, but we would suggest that the larger issue was that the property itself did not command a high enough premium, and that's why they chose not to.
But it was no reserve.
That's correct, Your Honor. And however, within the document, while there's no reserve specifically stated, there is language that seems to abrogate this idea of an absolute auction. And while we recognize and admit that the document that was admitted is a document that was signed by the parties, and what they're not being...
You have a hard argument. I'll just say that.
Yes, Your
You have
Honor.
a difficult argument.
Yes, Your Honor. Yes, Your Honor. So, as it relates to that, there are some terms I think that the court can look at and question as it relates to this, of why provide a statement of some kind of lump sum payment in the event of a no sale? Why provide the recovery?
Excuse me for interrupting.
Yes, Your Honor.
As I understand the auction listing contract, it's been checked absolute without reserve. Is that not clear?
It is, Your Honor. So yes. So as Your Honor admits to, as you've referenced on the first page, property to be sold, the check mark is written absolute without reserve. However, we would say that there are some terms that would seem to contravene that. When we think about an absolute auction, we think of something that, there's no provisions at all on it. That it's an absolute auction to be sold at whatever the highest and best bid is at that point in time. However, within this document, we have provisions that are being provided for as a reduced buyer's premium if it's a partner, reduced buyer's premium in other events, and in the case of a no sale, importantly, the fact that there's going to be this award of damages and agreed upon sum. So the fact that a no sale itself is contemplated, we would argue, indicates that there was at least contemplated between these parties and understood that the property might not sell at all. And why it might not sell may be for a variety of reasons, one being perhaps that it didn't bring enough at the auction block.
Well, it sold, it just wasn't paid for.
Yes, Your Honor. So obviously the auction concluded, but there was no exchange of consideration, certainly. I understand that. Again, the extent of the parties' obligations under this contract, it should be tempered by a reasonable standard. That's from McLean versus Kimbrough Construction Company. Courts can't make new contracts for the parties. Obviously, the parties are stuck with the ones that they have come up with between themselves, this bargain that they have. And courts are not to favor necessarily either party in the construction of an agreement. The court found in this case that they incurred expenses in the amount of $16,000 $41,550, which, taken with the bargain for fee of $25,000, arrives at an amount of $41,550. As it relates to the findings of attorney's fees in this case, there's no particular findings of fact or conclusions of law in the order related to the fees provisions. There was not an affidavit that was subsequently submitted with that, and therefore we think the court didn't do its due diligence in making that award of an attorney's fees under this contract provision. As it relates to an idea of fixing reasonable attorney's fees, Tennessee Supreme Court Justice William Faunus concisely stated these facts with the time that devoted to performing the legal service, the factors, the time limitations imposed by the circumstances, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal services properly, the fee customarily charged and locality for similar services, the amount involved and the results obtained, and the experience, reputation, and ability of the lawyer performing the legal service. And here, none of those factors were considered by the trial court, nor was there any proof or provided as it relates to that, other than just simply the amount that was incurred by the attorney arguing the case. In all actions that are tried without a jury, the court shall find the facts specially and shall state separately its conclusions of law and direct the entry of the appropriate judgment. Here, that simply didn't occur. For that reason, we think also that this case should be reversed and remanded and sent back to the trial court so that it might explain its decision and provide the parties with that understanding and with that knowledge and facts that would be requisite for us to have a better understanding of how that number was relied upon. In closing with this portion, Your Honor, we think that this contract simply weighs heavily against the appellee in this case, the Amonett Eagle Auction Online, for a number and variety of reasons, specifically as it relates to the clear, unquestioned terms of the agreement that in the event of a no sale, that there was a specified damages amount that were to be paid by my clients, an amount that was clearly written into the contract, into the blanks, and provided for under the sections. Trial court failed to assess those damages appropriately and interpret the contract as was written between the parties. Therefore, this case should be reversed and remanded. Thank you.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
May it please the court. William Birdwell, Putnam County Bar. I represent the appellee in this matter. It's important for this court to understand that although the plaintiff sued this matter.
Pull the microphone down just a little bit, be sure we can hear.
Yes, Your Honor.
That's better. Thank you.
All right. Your Honors, the court made a finding of fact that fraud had occurred in this case. And although breach of contract was one of the causes of action pled, there were more fraud allegations pled, causes of action. And when the judge ruled, he ruled on fraud, and he delivered a judgment based upon fraud. And when he did that, it led him to the measure of damages that he's required to follow when determining damages. And he was required to compensate the injured party for actual injuries sustained to put him in the same position that he would have been had there been no fraud. And that's what the judge did in awarding a judgment for the value of the time of my client and also to reimburse for attorney fees. I think it's important to note that the appellant's argument is based upon a situation where the court would have ruled with a breach of contract finding and followed the measure of damages prescribed for a contract breach. That's not what we have here. The court found that there was a fraud perpetrated by the appellant. The court found that my client had been damaged, and in following the law, ordered two judgments that were designed to compensate him for the actual injuries sustained. Let's talk about the value of his time. With the value of his time, the court found that through fraud, my client had been unduly influenced to enter the contract, to set up the auction, to perform the auction, and spend all the time doing that for no compensation because of the resulting fraud by the seller in bidding on their own property and disenfranchising the bona fide purchasers. That was in the final order. All of those findings of fact were in the final order. And when the judge orders a compensation for actual injuries, he can't give my client his time back, so he must compensate him for it. So the question really at this point is not what the contract says, because the judge is not ruling on the contract. I understand that contracts prescribe damages and limit them in some instances, but this is not a contract order that's been appealed. It's a fraud order. And so in order to compensate him for his time, he relied upon the testimony of my client, who the court found to be credible to testify because he's a licensed auctioneer and real estate broker and owns and operates an auction company as a full-time profession. There was no other evidence entered to give the judge guidance as to the value of the time. With that, the court made a determination based upon the testimony of my client that the value of time spent by my client to organize and conduct the auction was $65,275 based upon the facts of the case, the property where it lay, etc. And oddly enough, the market bid by the appellant. And he ordered that, not as a commission under the contract, but as a value of time in order to compensate him for his time. In that regard, the law authorizes that order, and oddly enough, there was no challenge by the appellant as to the value placed on that time. The argument of the appellant is that the judge should not have ordered that, but should have retreated to the contract, stayed inside the confines of the four corners of the document, and awarded $25,000 rather than $65,000. There is no argument that the value determined by the court was wrong. The argument by the appellant is that he shouldn't have used that. He should have used the $25,000. But like I say, this is not a breach of contract case. The attorney fee. It's the same premise. If you look in the statement of proof and the order of the case, my client testified that he had spent, through the date of the trial, $10,000. Now, if the measure of damages for fraud is to compensate for the actual injuries sustained, if he spent $10,000, he needs to be reimbursed $10,000. But there's a question: is it reasonable? Well, there's a finding of fact by the judge that it was a reasonable award of attorney fees. And what did he base that on? Well, if you looked in the technical record, my client introduced all of his attorney bills into the court. So when we were in court, there were itemized attorney bills with descriptions of what was done and the time and the amount charged and all of that could have been objected to at the trial. It was not. Also, in the same vein, if you'll notice, the objection to the attorney fees is not the amount awarded. It's that with that amount was not some sort of special recitation of the reasons supporting that. Maybe semantics, but I don't think so. The test for your honors is to determine whether or not the trial court put enough facts into the order to guide the appellate court, the reviewing court, to show it how it came to its conclusion to award a $10,000 attorney fee. And the court did. If you look at the order, many, many paragraphs of finding of fact. Fraud occurred. My client was damaged because of the fraud. The court specifically found that the attorney fees were the result of the fraud of the appellant. The attorney bills that were a part of the record, the testimony of my client that he actually incurred and paid that amount. Not to mention the other findings of fraud that caused my client to have to spend that money.
What were the false misrepresentations? What were the false misrepresentations the court found were made to induce your client?
I apologize. I am not checking my messages. I am saddled with an insulin pump that there's a whole other book on how to trick it so that it won't give me insulin when I'm up here, and one thing's to take it off, but it seems to be reminding me that, hey, I'm in your pocket and I'm not plugged in. So if you'll bear with me for 7 more minutes, I'll be fine. I'm good.
Understand that we don't want to prevent you from doing anything you need to do to.
Don't call the ambulance, okay?
Every now and again, somebody's phone goes off in court, and it's really embarrassing.
Mine did this morning.
One of the circuit judges one time didn't realize it. It was an odd moment.
Yes. First you look around.
The
Other people say.
The final order and the statement of evidence is an interesting read. It's basically the same thing. The court is very complete in its finding of fraud. It first starts by finding that the representations made to my client that we agree to sell at an absolute auction. We will not bid on our own property. We will sell to the high bidder.
Let me ask you about that we will not, I mean, the trial court said that.
Yes.
We will not build, but what do you make of the other, I guess the handwritten other condition that talks about 7% of the 10% buyer premium is in the event a partner purchases any property.
Well, okay, this is an important distinction. The argument wasn't clear by the appellant that there's a distinction between the company that owned the property and the company that bid the high bid in. The court made a finding of fact. It was the company that owned it that cast the high bid and refused to close, not the partners. These partners, as individual men, were interested, I suppose, in buying the property from the company. And so the mechanism by which to do that is to show up at the sale and bid it in. We're talking about two different entities. One's a company, and the other two entities are individual men. That's why that is written in there. It is not a special election or a pass to the ownership company to be able to bid it in and then not close. That was an agreement at the end with the individual men that if one of you buys the property, you'll pay less of a seller's premium, is what they call that. That's why that's in the back. It has no bearing on the duty of the selling company to not bid on its own sale, to not run off good faith purchasers, and refuse to close. Let me say this, Your Honors, if I've answered your question. The contract would make for a fine discussion. Interpretation, differences of opinion, is there ambiguity? Do we need extrinsic evidence to explain these things? The court didn't go there. The court made a finding of fact based upon fraud. He made a ruling for damages based upon fraud. He was not confined by the four corners of the contract because he didn't rule on a breach of contract. The brief of the appellant is a fine argument as to interpretations and differences of opinion, but this is not a contract case. You can't appeal an interpretation of a contract if the court did not rule on the contract. The court ruled on misinterpretation, misrepresentation, basically lying, and it hurt my client. That's the case. It's a fraud case. It's not a contract case. The argument of the appellant is misapplied here. This is not a contract case, and the judge didn't rule on a contract. The conclusions of law, based upon the facts found by the judge, don't require a viable auction contract. Going to the third argument made by the appellant, it wasn't discussed, but the third argument is this contract should be void against public policy. Even if this contract was considered void, it doesn't upset the ruling of the court, because a viable contract is not a basis for which to find fraud. It's not one of the elements of fraud. There has to be a misrepresentation. There has to be a reasonable reliance. There has to be damage to my client. And The court found, as a matter of fact, that he had no idea about all this fraud until after the auction was concluded. That's the case, Your Honors. It's not a contract case, and whatever's in the contract has no bearing on your decision, because you're not reviewing a decision based upon the trial court's interpretation of a contract. You're reviewing the trial court's determination from a plaintiff that the court found, as a matter of fact, to be non-credible, could not be believed, stated it in the final order. That's what you're reviewing, not a contract review. If you have no questions, that's all I have.
I hear none. Thank you.
Thank you, Your Honors.
We'll hear from the appellant rebuttal.
Thank you, Your Honors. Rising to respond to my worthy adversary's arguments this afternoon as it relates to the matters before this court, whether the court would make a determination about fraud or any kind of misrepresentation. In order to even be at that threshold, to even have that discussion, there had to have been a contract between the parties. That's ultimately what brought the parties into communication with one another. That's what has bound them together, and that's what created these expectations. As the court is well aware, we have a statute of frauds in the state of Tennessee that says you can't transfer any kind of real estate without some kind of written document, can't engage in a number of activities and commerce without a written instrument, and this is the written instrument between these parties. Therefore, even though the court discusses misrepresentation and fraud, the contract is still relevant, and it's still something that the court should consider and look to in making a determination of damages and making a determination of what it was exactly that the parties agreed to or not, specifically as it relates to this idea of misrepresentation and fraud. Because the document itself gives us evidence of what the parties knew or didn't know about this understanding. There's five factors when it comes to a fraud determination. You have to have a false statement or an omission of a material fact, knowledge that the statement was false, an intent to deceive, reliance on those false statements, and then finally damages. As it relates to the case before this court, there's no question through an online auction that the plaintiff in this case was the administrator of. He would have had full access and knowledge of who had registered to bid, the names of these individuals, the email addresses, all those things, so that these bidders would not have necessarily been unknown to them, or that there would have been any misrepresentation of the fact that the Norris brothers themselves were bidders and had organized an entity to bid it on this particular contract. The status of Amanda Peregrine in this case is a moot point, because ultimately she was not the highest bidder in this case. So whether or not she should have bid on the contract, or whether she was a shill bidder, is immaterial as it relates to the determination of damages and before this court to rely upon. Rather, we should go and look to the actual contract itself.
I'm sorry, she was not the highest bidder?
No, Your Honor, she was not. The evidence that reflected in the final order was that the entity or one of the Norris brothers was the ultimate high bidder on this case, not Amanda Peregrine.
Okay.
If I've misstated that, then I apologize, but that's my recollection of the facts. As it relates to this case, Amanda Peregrine was one of the bidders. There's a total of 11 bidders in this case. As it relates to this matter, Your Honor, again, we looked at this contract, and through that we understand what the damages are and arrive at that understanding. Thank you.
Court's thanks to both of you. We appreciate your briefs and your oral argument on this, and enjoy your drive back to Cookeville and Clarksville.
Yes.
Did I
Thank you.
get that right?
Yeah. Thank you.